Let's go.
Hi, this is Billie Tarasio with the Modern Divorce Podcast, and I want to introduce you to our newest law clerk, Kaela Gray. Kaela, say hi.
Hi, everyone.
So Kaela just asked me, she is a recent law school graduate. She's new to family law. She wants to do family law. And she said, Billie, can you tell me all of the documents that happen in a family law case so that I understand when somebody gives me an assignment, where these things fit together? So a lot of people have this question, not just you. So let's talk about it. Every single case, whether it's a divorce, an establishment of custody, or a modification or an enforcement action. There's really only 4 types of family law cases. It's one of those 4. And every single one of those cases has to start with a petition. So pleadings are only petitions, responses, counter petitions, third-party petitions, and responses. That's it. That's what pleadings are. And every single case starts with that. Then after that is served, or an acceptance of service is signed by the person that's opposing, then they have a certain amount of time to file a response. And the response is the second pleading. After that, and at any point in time throughout a case, someone can file a motion. These are not required documents, but anytime you ask the court for anything, or anytime you have a request of the court, you file a motion. The motion does not have to be served. It just has to be delivered. And then the opposing party, the person who's being served that motion, has usually by default 10 days to respond. Now, it's not always a 10 days to respond. And so what I often do with my clients is have the paralegal give the court a call and ask them, what date do you have calendared to review the motion? And then you basically have until that date to get your response in. And depending on if you want to slow the case down or speed the case up, you may want to take your whole time, or at least know how long you have to file that motion. Now, in a typical, do you have any questions so far?
No, so far so good.
Okay, so in a typical case, after the petition and the response, the next thing you might see is a motion for temporary orders. The motion for temporary orders could be for anything, any temporary order you want. And the rule will tell you what you may ask for. So there's 2 places you can look to find the rules. There's 2 types of rules. There's the rules of procedure, which is the Arizona Family Law Rules of Procedure. And then there's the substantive rules, which is Title 25, which tells you, like, substantive rules are when determining spousal maintenance, here are the factors. Procedural rules are when asking for temporary spousal maintenance, here's how you do it. Make sense?
Yes.
Okay, so the next thing that usually happens in a family law case is an RMC. And that's a resolution.
Okay, yeah, that was what I was just going to ask. What does the RMC stand for?
That's a resolution management conference.
Okay.
And the resolution management conference is a non-evidentiary hearing in front of a judge to talk about the case. What are the pending issues? How do we get some resolution? And if you do, or for people familiar with other types of law or other areas of law, this might be like a pretrial setting conference. And so you do have to file an RMC statement before that. And the RMC statement is supposed to be not argument. So like a motion, you argue your point. You ask for something, you give the court the authority that you have, that it has, in order to order what you're asking it to do. And then you argue why you want the court to grant your motion. In the RMC statement, you're just listing without argument, here are the pending issues, here are the positions. Here's mom's position, here's dad's position. Sometimes
Does each side say their own positions as well as the other positions? Like, are there 2 almost identical documents?
You only have to put in your own positions. But if you want to start telling the court about why you believe your position is superior, you're not supposed to argue, but there's usually a little bit of positioning. This is your first impression in front of the court. You do want to make a good impression and thoroughly explain both the facts and your position. So,
Okay.
yeah, and different people do RMC statements differently. Sometimes people do very thorough RMC statements, and other times people don't. And you don't, it's not required to be very thorough, but in our practice, at least, we try to be as thorough as possible. Any front loading we can do in terms of work only makes the case go smoother. So there's a couple other documents that you usually want to have done by this time. One is an affidavit of financial information, which is required in every case that involves money, including attorney's fees. So almost every case requires an affidavit of financial information. And then the other document that we recommend, and we like to have every single client do, is an inventory of property and debt. So systematically writing down what are all the different pieces of property and what are all the different pieces of debt, so that we get a really good idea of what does the community have. And then we determine, are there arguments or disagreements about the character of property, what's separate and what's community? Or is everything community and we know the values? Do we have to take steps forward to figure out values of things like houses or valuable collections, or is everything quite clearly the value that it has? So it really does help us to go ahead.
Oh, for those, I didn't want to interrupt you. For those affidavits, do you just take the opposing party at their word? Or I know like we've done some discovery requests for people's bank statements and credit card statements. Is that always required? Or do you sometimes, I feel like you don't just take the other party at their word.
No, you don't just take the other party at their word most of the time. Now, it depends on how the parties ran their finances together. If both people have basically the same access to information, all the accounts are joint, everybody has access to statements, there's no reason to do discovery.
That makes sense.
If we don't know what the other side has, or we feel like they're lying, or there's been some dishonesty and some hiding of assets, then we may go through a discovery process. And discovery are documents that are not filed with the court. They're just documents served on the other party and their lawyer. And they are for the purpose of gathering information. You do want to start this far before your RMC, which is why we do that property inventory and debt inventory, because that leads the conversation of, is there more we don't know about? Do we have access to all the information?
Okay.
And then if we don't feel like, if we have real reason to believe that the other side is not giving us the right information, even with our discovery, they're not going to give us good information, then we may want to do subpoenas. Subpoenas are orders that the court issues and we issue as lawyers to companies that say, you have to give us this information, here's the deadline. And companies usually respond to subpoenas, and then we get information and we can ask for all sorts of information. So it's important in the very beginning. The reason that we have strategy sessions and that we have discovery and disclosure meetings with our clients is to determine what might be out there. What do you think is out there? And how do we want to get that information? And then we want to do a cost benefit analysis. How much money are we willing to spend to get the information that might be out there? Do we think it's worth it?
Yeah, that makes sense. So that's the first step, is you figure out what the parties have.
Right. In a divorce, we've got property issues and then we've got kiddo issues. And in terms of property, the first step, and really the step that can take a long time throughout a case, is determining what is out there, where is it at, when was it acquired, and how do we split it, if we're splitting it.
Okay, so what step comes after that?
After you've gotten all of the information, you feel confident you have all of the information, now we should be able to make some settlement offers. We should be able to go to mediation. We should be able to get this part of the case locked down. We need to determine, are there legal disputes? Do we disagree about the value or the character? Character is separate or community. Do we disagree about any of these things? Like, for instance, if there was a business that was acquired or started before the marriage, but it grew during the marriage, we've got valuation issues, we've got character issues. If there's an inheritance that got used for a down payment on a house that's now titled in both people's names, we've got character issues, we've got division issues. So we need to itemize the property and determine per piece of property, is there a disagreement on this or not? If there is a disagreement, how do we want to go about solving that disagreement?
Okay. So then, so is that all discussed in a settlement conference? No files need to be filed either way.
Say that question one more time.
So when you're discussing anything that you agree on or disagree on, that's just a discussion, normally over email or in person, and you don't actually have to file any documents for that?
Right. Settlement discussions and negotiations do not get filed with the court. They are a process of the lawyer meeting with the client to determine and really get the client's position pinned down. Now, one of the things we do at Modern Law is we have at a minimum, we send out a monthly client status memorandum to let the client know exactly what's going on with the case, where we're at, what our position is, and to make sure that we are on the same page with our client as to what they want. Once we get on the same page with the client as to what we want, then we talk strategy. Now, how do we get you what you want? Do we think that this person might be amenable to settlement? Can we simply send a letter with an offer, and are they likely to accept it? Or do we need to go to mediation?
Okay, so then after everything has been discussed, do you go back to the original petition or motions that are filed and amend it for a decision? Or like at the end of the settlement, I guess if they disagree, they probably go to trial and then the court would make that determination. But I'm assuming more stuff needs to be filed if you're going that route.
That's a great question. Nothing has to be filed with the court to change the petition or to amend different motions. Once agreements are made, if they're partial agreements, then we file a Rule 69 agreement for the judge's signature to adopt the partial agreements. If there's a full agreement, then we would write down a proposed consent decree. It would get signed by both parties and it would get sent to the judge for the judge's signature.
Okay, so that's for the stuff that the parties agree on from the settlement conference.
Yes.
And if there is a disagreement, they can settle what they agree on, but the disagreement could go to trial.
That's exactly right. So let's say that all the properties get decided. Those are all settled, but we disagree on spousal maintenance, or we disagree on parenting time, or on child support. We could go to trial on any sub issue or none.
Okay, and then that just follows the normal timeline of a trial.
Right. So usually what happens at the RMC is most of the time judges don't set trials. They set a deadline for discovery and disclosure. And then they set maybe a status conference where they want to know from the lawyers, what have you guys resolved? Because I don't want to set a trial and designate certain time to hear this case without knowing which issues need to be heard and therefore how much time we need in trial.
Okay, so the judge wants to know what they're going to be getting into down the road.
Yes. So judges issue minute entries. Minute entries are deadlines and orders. They are rulings that say, you have to have your stuff in by this time. We have a trial date of this time. You need to file your exhibits and your pretrial statement by this date. And minute entries can also be, we heard the temporary orders hearing and I took the matter under advisement and here's what I'm issuing. Here's my ruling. So minute entries are court orders.
Okay, are there ever situations where it's just the attorneys and the judge and the parties aren't present? Like, would that, like the deadline and timeline stuff be discussed without the actual people involved?
Yeah, so there are times when a lawyer will waive a client's appearance or the client won't want to be there. And that's a strategic decision and a practical decision. So, but it is possible in certain cases. When the parties have to be there, there's an order to appear that's issued by the court or a minute entry that says, the clients and their attorneys have to show up at a certain time.
Okay, awesome. That was very helpful. Because I was wondering about that, because I feel like parties are probably pretty busy and they don't necessarily have the most time, depending on different people's situations, or they might not personally want to be around the other person.
Absolutely. Absolutely. And then, there's a lot of other things like depositions, for instance. Clients don't have to attend the deposition of their spouse. And, sometimes it's a good idea that you don't attend that deposition.
Yeah.
So any other questions?
When the issues are resolved at the end of the case, is that just the parties waiting for the judge to say, here is my determination on these unresolved issues, the end? And that's just like a waiting game after the last step of the trial?
Yes. So after the trial, the judge typically takes the ruling under advisement, and the judge has 60 days to issue his or her ruling. That ruling is then delivered to the attorney via email. And then we go over the ruling and we decide, what do we do now? Are there issues that need to be clarified? Are there fundamental mistakes that can be appealed? Are there issues that are unresolved that still need to be dealt with? So you're not necessarily done when you get that decree, but mostly you are done when you get the decree. And then usually at that point, the lawyer will have a closing meeting with the client, file a motion to withdraw, and the case is closed.
Okay, so that's the last step.
That's the life cycle of a family law case.
Thank you. That was exactly what I was trying to figure out.
Awesome. Well, I'm so glad that this has been helpful. And if it's been helpful to you, then I'm sure it'll be helpful to our listeners as well. So thank you, Kaela.
Thank you, Billie.